Friends, today we are going to discuss the Satyendra Kumar until judgment part 2, which prescribes guidelines for issuance of bail and various categories, how it has divided the offences. So what are the prerequisite conditions, what are the points to be considered while granting bail. So all these aspects we will discuss now. Okay, come to categories. Already we know that part 1 we have discussed the directions issued, the ultimate directions issued in Satyendra Kumar judgment. Now come to various categories. What are those categories? Broadly, the Honorable Supreme Court, four categories have been issued regarding offences. So first category is A category. Offences punishable with imprisonment 7 years or less. 7 years or less. Not falling in category B and D. So category A offence is that which is having punishment either 7 years or less. So that is one type of offence. It is not falling under B or D. That is one. The second offence is, that means we can call it as less punishable. Less serious. Less punishable means less serious. That is one category. The other category is more than 7 years. The offence punishable more than 7 years. Death, life or more than. The C deals with the offences mentioned in the special acts which are having stringent bail provisions. That means you take NDPS Act. In NDPS Act, getting bail is difficult. You take Prevention of Money Laundering Act. It is also difficult to get bail. Like that UAPA, Unlawful Prevention of Atrocities Act. Like that UAPA Act, Unlawful Activities Prevention Act. So, like this. Come to D. Here it deals with the economic offences not covered by special acts. So, economic offences. It deals with economic offences not covered by special acts. These four categories have been prescribed by the Supreme Court. In this judgment, the whole effort of the Supreme Court is to give guidelines to the magistrates and high courts and also as well as other governments to make bail as a liberal, to make bail granting bail should be made as a liberal, because what? Unnecessarily the power of arrest is being used by the police. Unnecessarily number of under trial accused persons, prisoners are languishing in the jails. So, by giving great respect to the personal liberty, Supreme Court made a very good effort, made a very good exercise by categorizing, by giving guidelines. So, four types of categories have been given. These, while granting bail, courts has to take which type of offence it is there in the present application, in the given application. So, the offence given in the bail petition comes under which category? First they have to take into that aspect. The other is requisite conditions they have to take into consideration. What conditions they have to take into consideration? What are those conditions? whether the accused cooperated during the investigation. So that means not arrested during investigation, that is first aspect. That means what? Investigating agencies have not arrested during investigation. That means what? Charge sheet filed or proceedings closed without arresting the accused. That means there is no necessity for arresting now. There is no necessity to keep him in jail now. That is one aspect. The other thing is whether the accused cooperated throughout in the investigation, including appearing before an investigating officer whenever called. Whether accused cooperated or not. When a notice issued to him to appear before him, whether he appeared or not. So, cooperation of the accused, not arresting of the accused has to be taken into consideration. These two conditions. In economic offences and in regarding Section 170 CRPC, while filing charge sheet and other things, we have to send the accused before the magistrate. But regarding that, court in Siddhartha versus State of UP, in Siddhartha versus State of UP, in Siddhartha versus State of UP, court held that no need to forward such accused along with the charge sheet. So, under section 170 CRPC, accused shall not be sent to, there is no need to send to magistrate while filing charge sheet. That has been given clarity. So, come to category A. So, this is the classification of offences. This is the conditions to be taken into consideration. Okay, then, after filing charge sheet or complaint, taking up cognizance, what is the magistrates or courts have to do? We know that NI Act or private complaint, after taking cognizance or filing charge sheet, what is the procedure for appearance of the accused? Court have to issue summons. So while issuing this enforcement of the issuing proceedings before for enforcement of the accused, what is the procedure courts have to follow? That was explained by the Supreme Court. First, what is the first step? They have to issue ordinary summons. They have to issue ordinary summons at the first instance, including permitting appearance through lawyer. So at first stage, summons has to be issued, or lawyer appearance through lawyer has to be, can be permitted. The second stage, bailable warrant for his physical appearance. Suppose when bailable warrant can be issued, suppose accused does not appear despite service of summons. So that is second stage. Third, when non-bailable warrant can be issued. Summons, bailable warrant, non-bailable warrant, thereafter cancellation of non-bailable warrant. Normally first summons. If he does not respect the summons and even after issuance of the summons he does not appear, then bailable warrant for physical appearance. Even then he failed to appear, then non-bailable warrant. Fourth one is cancellation of the non-bailable warrant. When non-bailable warrant can be cancelled or converted into a bailable warrant or summons without physical appearance of accused, without insisting physical appearance of the accused. It is important. Normally it is very crucial while filing bail application whether physical appearance of the accused is necessary or not. In some courts are insisting for physical appearance of the accused, but Supreme Court says even for cancellation of the non-bailable warrant, dispense with of the appearance of the physical appearance of the accused can be done. So without insisting physical appearance of the accused, if such application is moved on behalf of the accused before execution of NBW can be cancelled. But the condition is that before execution of the NBW, application has to be moved. Even after issuing of the NBW, before execution of the NBW, any application filed for cancellation of for revoking of the NBW, then it can be considered without insisting on the physical appearance of the accused. And an undertaking, by taking an undertaking for the appearance next hearing. Okay, then bail applications of such accused and appearance may be decided without the accused being taken in physical custody or by granting interim bail till the bail application is decided. So, after filing that NBW, cancelling the NBW, bail application, his bail application can be considered on appearance may be decided. Because of warrant has been cancelled, he may appear. After appearance, his bail application can be considered, decided. May be decided without the accused being taken into physical custody. So then also there is no need to take in physical custody. Otherwise, interim bail can be granted. So this is the procedure to follow. Okay. Then category A completed now. Come to category B and D. So B and D are serious offences. So what is the duty of the court? On appearance of on merits it has to be decided, on appearance of the accused. On merits. Application be decided on merits. That is B and D. Next, D is economic offences, B is serious offences. Come to category C. What is category C? The acts, the offences mentioned in the special acts which is having stringent provisions of the bail. That means normally bail cannot be granted. So this is also, these bail applications also can be considered as per B and D. That means on merits. That means on merits. But as apart from on merits, court in category C offences, court has to take in the consideration of additional conditions of compliance of the provisions of bail. So if there is any additional conditions mentioned in special act, then those conditions have to be taken into consideration. Suppose in these cases, before granting bail, PP argument has to be heard first. So that condition has to be taken into consideration. So this is regarding C. So B and D completed, C also completed. Okay, what is this? In A category, offences may be two types. That is by private complaint or by police complaint. So in those categories, in both categories covered, that is the statement. Okay. So these are the categories and these are the conditions and guidelines while considering the bail application of the accused person in variety of offences. Then when cannot be granted? When cannot be granted means where the accused have not cooperated in the investigation, it's common, nor appeared before the investigating officers, nor answered summons, or when the court feels that judicial custody of the accused is necessary. So 4 conditions. When he is not cooperated, when he is not appeared, when he is not answered, or when court feels that his judicial custody is necessary for his custody is necessary for the investigation. In these four conditions, the above relaxations, the above rules cannot be applicable, may not be applicable. So this is the important aspect. Regarding the economic offences, we have to take into consideration in one judgment is there. According to the judgment, what has to be taken into consideration is the seriousness of the seriousness of the offense charge, the seriousness of the charge and the severity of punishment. Sanjay Chandra versus CBI case, Supreme Court held that, and while considering the bail application in economic offences, these has to be taken into consideration. So these are the categories and guidelines of the bail.